Hello everyone, in this video I will be telling you my test experience and how I scored 89 marks in Set C Arbitration Self-Paced Online Module CA Final Examinations. First of all, I am very happy to share my experience and I hope you will all be waiting to hear my experience. Let's get into the video. First thing is, I have prepared notes from the IC study material. I have studied from the IC material and other sources also, and I have prepared notes which summarizes the content from the IC study material. I have uploaded those notes in the Telegram channel. You can refer to those notes by joining the Telegram channel. And I have also uploaded questions. For both IC study material and other questions, I have uploaded video which explains the answers, and I have also shared the PDF of questions in the Telegram channel. You can also refer to those. First thing is, if you are going to follow this approach, first thing you have to get is conceptual clarity. For getting that, you can refer to my videos which are uploaded in the YouTube channel Mission CA with Vikrut. In this channel, I have uploaded videos for all the chapters in the Arbitration Act, except for the introduction part, which has very less weightage. That is why I have not covered it in the video, but you can read it from the study material, or you can refer to any other notes for preparing for that chapter. For all the other chapters, I have uploaded videos. Those videos will be helpful for first timers, first time learners, or for revision. For both the purpose, it will be helpful for you. And then after referring to that, you will be getting the conceptual clarity. Then next thing is, you have to revise the content and you have to make it retain. You have to retain the concepts. For that, you have to read from the notes. The notes I will be using in the video, the same notes I have uploaded in the Telegram channel. It summarizes the content from the IC study material that you can refer to study from it, and you can make revisions from that. And then for practice, you need questions. That questions also I have uploaded in the Telegram channel. You can refer to there for questions. Now these are the simple steps that I follow to pass in Set C arbitration and get 89 marks. I hope this will help you. The next part of this video is about what are the questions that were asked in my exam and what are the important concepts that got tested. It may include last minute tips also. What are the points in which you need to focus on the last minute? What are all the points you should not leave? Like that, those things I will be covering in the next part of the video. Let's get into the second part of this video. And then before going to the next part of the video, I would like to show you the channel in which you have to refer the videos. This is the channel. You can search for Mission CA with Vikrut and you will get the channel. And here in the playlist section, I have created a playlist for the Arbitration Act. In this playlist, all the videos are there. From part 1 to up till the last part I have covered in this playlist. Every section will be covered here except the introduction part, as I said earlier. For every chapter you will find the videos. And then I have also made a strategy video, what approach you need to follow. The approach will be discussed in detail in that video. And I have also made videos for other MCQs other than IC study material and solving IC study material MCQs. These are also videos which you can see in the playlist. And an important case laws also I have covered in the video. And for these videos, you have to refer to the playlist. I have given the link of the playlist in the description. I have also given the link for joining the Telegram channel in the description. And then one more thing is, here in the video, I will be using the notes. This is the notes I am using in the video. These notes will be shared in the Telegram channel. For joining the Telegram channel, the link is given in description. The same notes you can read from using the Telegram channel. Now let us see the important concepts which were tested in the self-paced online module exams when I gave my exam. The important concepts were, first thing is challenging the award under section 34. Under section 34 you can challenge an arbitral award. For challenging you have to go under section 34 and make an application. You can set aside the award. That is a very important section and there are many detailed provisions. I have covered it in my video in detail. In that the most important points are time limit and grounds. Within which time limit you have to go and challenge. What are the grounds upon which you can challenge. Those are the important points from which I got the questions. And then award of interest under section 31. You can cover it in detail by watching my videos. That interest, how much percentage you have to charge. And then from what period to what period you have to charge. Everything you have to give special focus to those points. And then one case law, Balco versus Kaiser Aluminium. I have covered it in my important case laws video. That case law is also important, regarding which the case law was happening and what was the judgment given. I got questions from that also. And then section 29A and 29B. These are the time limit for arbitral award, and then the fast track arbitration procedure sections. In that, the time limit you have to know within which time limit you have to complete the arbitral award. I got questions with dates. In this date the pleadings were completed. From which date to which date you have to give the arbitral award. Like that I got the questions. And then extension of the time limit. For extending the time limit there are certain conditions that also you need to follow, and that is covered in the question which were asked in my exam. And additional fees. If the arbitration is completed within 6 months, additional fees can be given to the arbitrator. That provision also is important. And then section 7. As section 7 is very important, it is regarding the arbitration agreement, and many questions were asked from that section. It is a very basic section and everybody should know that before writing the Set C examinations. The main condition is agreement should be in writing, and then a reference to document is also a valid agreement. Those points I got the questions from. And then conciliation topic. Conciliation topic is by the name itself, it is very important and easy also. You have to definitely cover it. You need not leave it. I have given a 20 minutes video to cover the entire conciliation topic. Please, it is a must watch video. Please try to watch that video. In conciliation, what are the important topics are settlement agreement and its finality. What is a settlement agreement and what is the finality of it, whether it is final and binding or the parties can go and appeal on it, like that provision is important. And then submission of statement to conciliator, how the conciliator will communicate to the parties, that provision is also important. And then the finality of the outcome, whether the outcome of the conciliation is when it is binding, when it is not binding, that's also important. And then administrative assistance, section 6 of the Arbitration Act, that is also important, whether the arbitrator or parties can arrange an institution for arranging the documents, coordination and administrative work, whether they can assign any institution, that is also important. Correction or interpretation of award and additional award, this is also important. This comes under chapter 2 of the arbitration, fundamentals of arbitration, and in this is an important section, whether if there is any clerical mistake or typing error in the award, how you can change it, how many days you have to make application, within how many days the application should be completed, disposed of, like that also is important. And then mediation. Mediation is a topic in chapter 1 introduction that I have not covered in a video. In that mediation topic, the meaning of mediation, the stages of mediation, what are the characteristics of the stages, opening stage, what is the meaning, what will be happening in opening stage, in the closing stage what will be happening, that they asked questions. And then the finality of outcome, whether the outcome from mediation, whether it is final or not, that also they were testing the questions from. And then section number 25. In this section number 25 is regarding the default of the party, whether the claimant fails to communicate the statement of claim or fails to communicate the statement of defense, like that fails to appear in the proceedings. In that condition, what the tribunal will do, that is the important section. And then Singapore International Arbitration Council or Commission, that rules they have asked for 2 marks. I don't know where it is in the study material, but you can refer to it if you know where it is. This is also important. For 2 marks I got the question from that. Now we can see some important questions which were asked in my exam. First thing is basic principles of natural justice. The arbitrator is bound by the basic principles of natural justice. What are the principles we should follow while deciding the case? That is given here. This is, I have taken it from the study material. You have to see these options. In that there will be a 4th option which is incorrect. They are asking which option is incorrect. In that case you have to choose the 4th option. These 3 are the essential conditions. 4th one is the not a basic principle of natural justice. This question they asked for me. And then the second thing is doctrine of separability. The arbitration agreement is an agreement independent from the main contract. Even if the main contract becomes invalid, the arbitration agreement will be valid and it will be operative. You can make an arbitral award on the basis of the arbitration agreement validity. This is one important point. And then there are two types of arbitration agreement: arbitration clause and submission agreement. Arbitration clause is that when you start to draft the main contract itself, you are including an arbitration clause. In that you will be telling that whether any disputes, if they are coming, it will be referred to arbitration. And then before the dispute starts, you are making the arbitration clause. This is type number 1. And in the type number 2, what you are doing is, while the main contract is drafted, you did not include any arbitration clause. But when the dispute comes, both the parties consent and they are making an agreement that we will go to arbitration. This agreement is made after the dispute arises. So it is a submission agreement. According to the time of the dispute, the types are divided here. This is also one important thing which came in my exam. And then section 7 arbitration agreement, already I saw it is a very important section. Arbitration agreement by reference, that point is asked in my exam. Case law which decided the importance of parties' autonomy and consent in arbitration. This thing they asked. It was given in case law Arca Sports Management Private Limited versus Calci Buildcon Private Limited. There are numerous case laws given in the ICA study material. We cannot remember every one of them, but you can remember what is the decision taken in the case laws, what should be done to be abiding by the law, what should be done to follow the law. That is a conclusion you can know from the case laws. Only 2 marks I got the case law questions, not much. So you need not focus more on the case laws. You have to focus on the conceptual clarity. The next thing is, I got a question from foreign award definition under section 44, that you can refer to the section number 44 for reading the definition in depth. I have also covered it in my videos. The next point is, there is a point in study material saying that foreign lawyers cannot be debarred from conducting arbitration proceedings in an international commercial arbitration. This was decided in the case law A.K. Balaji versus Government of India and others. This you can read it from the study material. This is a small point given in the study material. I got a 1 mark question from this. Like this, there are very small points, but you need not recall and remember each one of them. You have to remember majorly all the concepts. If you remember all the concepts itself, you can get 70 to 80 marks easily. The next point is the Mediation and Conciliation Project Committee. In which year the government decided to implement the project committee? In which year they constituted the project committee? It is the year 2005. It is given in chapter 1 introduction. And then I also got a question from costs under section 31A. This section you can read it from the study material. I thought it was not so important, so I ignored it. But I got a 1 mark question from the cost section. This is the part where I got question from. You can read this from the study material. And in this act, there are 3 important dates. First date is when the Arbitration Act came into effect, 22nd August 1996. And then foreign award under section 44, there is the meaning, it depends on the date from which the dispute becomes commercial. The date on which law the disputes are considered commercial, that date is 11th October 1960. And in section 53 also, from which date you have to apply the Geneva Convention, on which date the dispute should be considered commercial, that law date is 28 July 1924. These 3 are the important dates, and there is no other date in the Arbitration Act. I got 2 questions from the date itself. 2 questions, each for 1 mark. Totally 2 marks I got from the dates. If you remember these dates, you will be able to answer those questions. Roughly, these are the most important and tricky questions which I got in my exam. I hope this will be helpful for you to clear your exams. Please refer to the videos and notes which are uploaded in the Telegram channel and YouTube. I have shown you the playlist and the channel also. I hope this will be helpful for you. Thank you.